former President Jacob Zuma has launched a counter application or a counter appeal application before the Constitutional Court to have 6 of the justices on the bench who presided over his contempt of court matter in 2021 recused from the ongoing matter with the IEC. When the Apex Court hears the matter between the IEC and the MK Party next week, Friday. This matter is currently scheduled to be heard on the 10th of May. Zuma is arguing, based on section 167(2) of the Constitution, that a matter before the highest court in the land must be heard by at least 8 judges. Zuma, and to some extent the MK Party, are contending in papers that at least 6 of the Apex Court judges are tainted by bias and are not fit to sit in the upcoming hearing, as they were part of the bench that sentenced him to 15 months of imprisonment without the option of a fine for contempt of court in 2021. Zuma, however, will need to prove this by meeting the stringent test of reasonable apprehension of bias, which would involve drawing substantial links between sentence and conviction, and the current hearing, which seeks to interpret section 47(1)(e) of the Constitution, which governs who may or may not be on a ballot. Joining me for this conversation is Advocate Michael Osborne. Michael, good evening, and thank you so much for your time. Really do appreciate it. As I understand it, the jurisprudence is quite clear. Just because a judge or a bench of judges and justices had presided over a case of an applicant or a litigant in one instance doesn't mean that they are apprehended from sitting and presiding and adjudicating over a case of that same litigant in a separate case should that arise. But President Jacob Zuma seems to make the argument that an adversarial judgment against him in the one instance contaminates and precludes those justices from being able to preside over him in this matter, given that there's a link between this particular matter and that 2021 judgment coming out of the Constitutional Court. To what extent will he be able to meet the apprehension of reasonable biasness test come the 10th of May?
Good evening to you. It's quite a difficult matter. As you mentioned, the test is not purely, or I should say Mr. Zuma can succeed even if one assumes that as a subjective matter, the judges are not biased. The question is whether there's a reasonable apprehension of bias on the part of an informed member of the public. That's the test. And that's difficult. Because, of course, the conception of what is a reasonable apprehension of bias, or what is a reasonable apprehension of bias, is difficult to pin down. You mentioned, correctly so, that the mere fact that a party in a particular case has in the past been before those same judges in a different matter doesn't necessarily mean, or does not mean at all, that the judges must recuse themselves. The thing that makes this a little bit more difficult is because there's a substantive connection between the decision in which Mr. Zuma was sentenced for contempt and this particular case, because something would turn on the interpretation of that earlier judgment. So the argument for Mr. Zuma would be that you cannot have the same judges who issued the sentence in the past then be called upon to interpret that sentence right now, because in a sense they've already made their mind up.
Yeah, but they're not being called, Michael, in this instance, to interpret the sentence. They're being called to interpret section 47(1)(e), which, if you read the Electoral Court judgment, simply means that they have to answer the question, given that there were 2 judgments. 1, does the president's remission powers have the effect of changing a principal sentence? 1. And in the second instance, whether or not appealability is substantive enough for him to be excluded from the impact of 47(1)(e) of the Constitution.
Well, you've very well made the response to the line of argument I was suggesting Mr. Zuma would follow. And indeed, I suspect that argument that you've just recounted that will be made against Mr. Zuma may well win the day. In the broader sense of the term, of the matter, you could say that the judges who issued the decision against Mr. Zuma in the first place would have had an understanding of whether or not this constituted a sentence or a conviction for purposes of future litigation such as this. So they weren't called upon at the time to make that interpretation, but you might say that they implicitly must have had a view on the implication of what they were doing.
Yeah, to test the bona fides of that substantive position, one of the justices that Mr. Zuma is asking to be recused from this case is Justice Theron. I mention her very specifically because in the 2021 judgment, she wrote the minority judgment, which argued that Zuma should not be imprisoned and should not be convicted. In fact, that the Constitutional Court had no powers to do such. Justice Theron made that argument, right, in the minority judgment, which holds no bearing except for academic purposes. But Mr. Zuma is asking her to recuse herself in this instance. Is that strategically wise?
I don't want to comment on whether it's strategically wise. I suppose on their interpretation, on Mr. Zuma's interpretation, the fact that in that particular, for whatever reason she stated in the minority, she voted in favor of Mr. Zuma there, does not mean that she too must implicitly have had an understanding of what the majority of the court was doing. That would have to be the argument.
Yeah. Just lastly here, and this again speaks to legal strategy here. 11 justices sit on the bench. 6 are being asked to recuse themselves by the application that President Zuma, Jacob Zuma had brought forward. If that is to be the case, it means that there will be 6 vacancies and not enough judges to meet quorum, which is 8. It means that Chief Justice Zondo will have to second from either Supreme Court of Appeal or the High Court justices to the bench to sit on this particular matter. If he's being asked to recuse himself and that argument succeeds and sustains, would it not place it under a very precarious position whether or not he could, whether or not he would be the right person to make the secondment appointment of justices to fill up the vacancies to reach quorum of 8 justices on the bench?
Well, remember that the Chief Justice has, in fact, voluntarily recused himself from this case. So he's not one of the subjects of the application to recuse. He has recused himself. In any event, it would then be the Deputy Chief Justice who would have to make that decision. And I don't think that's of especial significance here. Because the fact is that everything ultimately will turn upon the correct interpretation, or the rather ambitious interpretation, I should say, of the Electoral Court, which says that a sentence which is not subject to appeal is therefore not a sentence. I think that's a very, very difficult argument to make.
Because it means that the Constitutional Court would, a sentence coming out of the Constitutional Court would have no bearing. Meanwhile, a sentence coming out of a magistrate court would, because it's appealable.
Yes, it's paradoxical, isn't it?
Yeah. We're going to have to leave it there. Michael Osborne, Advocate Michael Osborne, thank you so much for your time. Really do appreciate it.